Hey, Mile High Pokemon back. This is Eli. We're going to be talking today about the judge's decision to Rattle's anti-slapp motion, which, if you remember, Rattle was trying to get the case thrown out, arguing that the case was filed in order to suppress his First Amendment rights and deter others from speaking. They went back and forth in the filings. I discussed those in my past videos. You can find links to that in the description below. And the decision came down in May or June. Gosh. Now I'm forgetting. July 2nd. The date's right there. So that's when this decision came down. So I'm late to covering this, but it's what spurred me to start the coverage again, because now we have movement. Now, unfortunately, the judge rejected Rattle's motion to toss out the suit. I'm going to go through this and discuss the reasons why. Going to discuss what I think about the judge's decision and where we go from here. So, first, let's read the quoted language from the statute that allows the dismissal at this stage. A person who files a motion pursuant to subsection A, has the prima facie burden of establishing that the legal action was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. So you have to prove that you were exercising a constitutional right, and you have to show that the lawsuit was filed to deter that or to retaliate against your constitutional right being expressed or exercised. A moving person may submit evidence based on the record, a sworn affidavit, or other evidence that is submitted with the motion to dismiss or quash. So altogether, as the judge points out, Rattle submitted 119 exhibits, and it was like 500 pages long. Rattle's own declaration, his own account of what happened, was like 50 pages long. Then Sean Bassik produced several exhibits as well. He had like another 300 or 400 pages or something like that. So in all, you had like 1,000 pages of records. So there was a lot there. If you remember, Sean was arguing that the case should continue because discovery has not happened and there was barely any evidence yet. But there was a significant amount. So first he discusses whether there should be a hearing or not, an evidentiary hearing. He decides no, which is maybe for the best because it would have cost a lot of money. But here I'm going to read what they wrote because there's barely any analysis on everything we went through. If you remember, it literally took several videos to talk through everything that was going on, and I didn't even get into the exhibits. I just discussed the, 80 pages of filings. I didn't talk about the hundreds and hundreds of pages of exhibits. And the judge essentially just gives a few paragraphs here of reasoning on why he's not going to toss the case out. So, defendants contend that the evidence shows that the lawsuit is substantially motivated by the defendants, by the plaintiff's desire to bankrupt defendants and to punish him for publishing truthful information, exposing plaintiffs' highly profitable improper conduct in the hobbyist community. Specifically, here are the three pieces of evidence the judge saw that Rattle had put forward. Number one, that plaintiffs filed this action only after their attempts to use YouTube's copyright and privacy law enforcement process to stifle defendants' plainly lawful speech. So essentially that YouTube had not abided by the requests, and that shows that the requests to take down the videos were meritless, and now they're just trying to retaliate in another way. So that's the first thing the judge said that he read or understood the argument to be. Number two, quote, Sean Bassik confided in at least one person, Rusty, a well-known and reputable industry insider, that Bassik intends to, quote, bankrupt the defendants. That's been a big deal here. And number three, at least 20 people have told defendants in confidence they're afraid to speak up about plaintiff Bassik's activities because he has threatened them or others with lawsuits in the past. So to the judge, these are the three arguments that he has to deal with. Okay? Now let's look at the reasoning. Significantly, Bassik allegedly said he intended to bankrupt defendants because he believed that Baristo, or Rattle, filmed him surreptitiously, not because of a desire to silence investigative journalists. Indeed, Bassik made the alleged threat on September 16th, a time when Rattle admits he was not yet actively looking into Bassik, nor did he at the time have any intention of necessarily doing so. Up until that point, Rattle had never mentioned Bassik's name in a Rattle Pokemon video. So, further, the court is not persuaded that the threats Bassik allegedly made to others a decade ago. So, the judge is saying, look, Rattle had not yet made any videos about Sean Bassik yet, and already, even before he started making videos, Sean Bassik said he wanted to bankrupt Rattle. It seemingly both parties admit this happened after Rattle had Sean Bassik in the background of one of his videos when he was taking B-roll when he collected Collecticon. So it wasn't the specific conversation he had with him that was recorded. He just showed up in the background. And allegedly, this was the reason for the lawsuit and not the actual, videos. That's what the judge's view of this is. Because of that, it was not actually filed out of retaliation for First Amendment speech, but in retaliation for videoing him. Then he says all this evidence of intimidating others was like a long time ago, and it all comes from essentially like forum posts on the internet, and it's not credible. There's no other evidence here of like people putting their names to saying like, oh, I was threatened recently by Bassik of getting sued. So that's the reasoning here. Now, this is ridiculous for a few reasons. First off, it's just like disrespectful that essentially you had both parties spend a lot of money on lawyers, like a lot of money on lawyers, and they did lots of work, and they submitted lots of arguments. It took me forever to even, like, I summarized them for you all, and it still took me hours to do, in terms of video content, and the judge only spends a few paragraphs. So to me, that's just like, on an initial matter, just disrespectful. As someone who's worked for judges in the past, I always try to consider all of the arguments being made and address them. So that's number one. But number two, the reasoning doesn't hold up, because first off, the lawsuit was filed to essentially the effect was to suppress Rattle from speaking and to take his videos down. So even if the motivation originally stemmed from something different, clearly the effect of the lawsuit is to suppress and deter speech. But the second thing, which is even more startling, is that video is protected under the First Amendment too. Not just statements, not just writings. Videoing is a protected medium of expression too. And if you're in a public place, you have a First Amendment right to video people, even if they don't want to. This is actually because this happens all the time where people get mad. People get upset, oh, I didn't consent to you recording me. Actually, if you're in a public place, you generally have a right to record anyone in a public place. There are almost no restrictions to that, unless you made another agreement or there might be some caveat. But generally, if you're walking down the street or you're in a convention and there isn't some explicit prohibition, I can take a video of you, even if you don't like it. So even if Sean Bassik did this lawsuit against Rattle because he had filmed him, that was an exercise of his First Amendment right. And so that would still qualify under the anti-slapp statute, at least in my eyes. Because whether you're suing him for the videos he made or the fact that he got you on video in a public place, either way, that is a First Amendment right that you're trying to shut down. You're trying to keep him from recording you in the future, which he's allowed to do under the First Amendment. So it's pretty shocking in terms of a resolution, especially just given the scant support here for the argument. So then Rattle's motion gets denied, and the lawsuit continues. He says Rattle needs to submit a reply. So where do we go from here? So essentially, Rattle will have to submit a reply to that original amended complaint. If you remember in the amended complaint, that's where Sean raised his claims, defamation, false light, and whatever else. And Rattle's response is going to have to go through point by point and say, yes, this happened. No, this didn't happen. This is being mischaracterized. I deny this. I approve this, whatever, right? Essentially, line by line, yaying or naying the filing against him. Then you move into discovery. Now, discovery can get really interesting because you have an opportunity to see each other's records. And almost anything related to the lawsuit is fair game. And here, specifically, Sean is alleging that Rattle defamed him. He's saying that he lied, right? So the content of those lies is all fair game. So Rattle could, for example, request any emails you made to any of these parties, any documents related to CGC, any documents related to communications with these other deals that you had in the works, any communication with Mathis about his at all. Let's see if there's any card altering going on, right? Because essentially Rattle is going to try to show, in addition to just saying this is protected by free speech, he's going to also try to show that I was telling the truth, or like my allegations were correct. And because of that, they're going to have wide access to each other's documents and records. Sean Bassik, on the other hand, is going to try to find something of Rattle's that shows that he either acted with actual malice, that he knew something was false and said it anyway, or that there was evidence that he had that contradicted what he was saying, but he refused to present to a viewer. So Sean Bassik, for example, will probably request from Rattle all of his Discord messages to people that could be related to him, emails, videos that hadn't been published yet that were like in draft form, stuff like that. And then on the other hand, Rattle's going to request everything from Sean Bassik that could prove what he's been saying. That could make for some interesting YouTube videos. Obviously, discovery stuff is public because as all lawsuits are, and the vast majority of court documents are public. So it could make for some interesting material if stuff about Sean Bassik comes out. The big thing is you're not allowed to, you have to preserve documents. So if it looks like you deleted documents or failed to produce documents that you were supposed to, there's a negative inference that's made. And what that means is that that the judge essentially has to infer that you were hiding something really bad or as bad as it could have been. So let's say, for example, there were records that Sean Bassik knowing that Mathis had altered the cards, right? There was an email or something, and then Sean deleted the email to make it look like that didn't exist, right? If there's another email later on that refers to it, so like it looks like that email should have existed because there's a reply or it's in a thread or something like that, then Rattle could be like, well, please give me this email that it's talking about. And if it's not there, then that would look really, really bad on Sean Bassik's part because it would look like he had removed information, and that could lead to negative inferences. And that goes both ways, of course. So that's going to be the next stage of litigation, is going to be this discovery. Now, the big thing is that this is all a very expensive endeavor. And I don't know, because I don't watch all of Rattle's videos, I'm not sure if he's discussed the lawsuit yet in terms of his next steps. But Sean Bassik hired some really good attorneys, including a former judge. And it's going to be very, very expensive for him to essentially litigate this, because he's probably paying $500 an hour for a lawyer. And even for rich people, lawyers are expensive. Going to trial altogether, by the end of this, if this really did go to trial, Sean Bassik could spend, $200,000, $300,000 on this whole thing, which is a lot. Even for the richest people, like, you'd have to be like a 10 millionaire, a deca millionaire, whatever the term is, for that not to really bother you. It's because it is a lot of money. And if Rattle doesn't have the means to pay a judgment, then it's not just, oh, you're spending all this money suing Rattle, but you're also not going to get anything out of him if he doesn't have anything to pay, because if Rattle is bankrupted by this, then that's it. I mean, you can't collect on someone who has nothing to produce. So, because after you usually go into bankruptcy, you get your debts discharged. So, if he's got nothing to collect and Sean Bassik's not going to get anything, you got to wonder whether Sean Bassik is really going to continue with the case. Because you got to imagine Sean's lawyer is telling him, listen, man, we thought that Rattle would cave. We thought that if we scared him into it, or he would like to try, one motion and try to get it thrown out, and it wouldn't be, we thought that he would settle, he would take down his videos. But now look at this realistically, like, do you really want to spend $200,000, $300,000? You might get his videos taken down. Who knows what a jury will decide? And at the end of the day, you're not going to get any money from him because he's bankrupt. So that's the sort of conversation that Sean is going to be having with his lawyer. And who knows, maybe pure spite can drive you that far. But to me, I can sometimes go out of the way to really want to get someone because of spite. That's happened to a lot of us. But would I be willing to spend a crap ton of money to do it? Not necessarily, even if I had the means to do it. Theoretically, it's just like a lot to invest. So you do wonder whether this is actually going to go to the very end, this lawsuit. And also, maybe Sean doesn't want to go into discovery, right? Sean knows that all of his dirty laundry is going to get leaked here, and Rattle's going to get a look at it, and Rattle's going to make videos about it. And until you win the lawsuit overall, he's going to keep talking about you, and he's going to look at your emails, and he's going to disseminate them. And, I mean, if you've got anything to hide, then Do you really want to go to trial? And do you want to go into discovery? Also, like, Rattle's going to get like 4 hours of one-on-one time or something like that, deposing Sean. Can you imagine? Sean Bassik has to sit for a deposition where Rattle is literally going to be like asking him all sorts of questions. Does he want to go through that? So there's a lot of questions here about how far this lawsuit's really going to get. Because it really sounds like Rattle is going to fight to the end one way or another. You know, Rattle's not going to have the same means. If Rattle only spends X amount of money and Sean has to spend 5 times more and he knows he's not going to get anything even if he wins in terms of monetary compensation, is it really worth fighting in the first place? So that's what I would say. Discovery will be interesting once they start doing it. I'm sure Rattle will probably update you all in a suit, you know, soon. I'm not sure. But I will keep you updated as I see documents getting filed. And I see what's going on. Yeah, so I think those are the main things. Please let me know if you have any other questions. Maybe we'll do a separate video answering specific ones. Oh, I guess the last thing I would say is that, in theory, I understand why you wouldn't want to throw out a lawsuit this early. Because essentially all that's happened is that there's been one side that's made a claim and the other that's made a motion to dismiss. You haven't had discovery. Sean's right about that part yet. And in America, we have this idea, right, that everyone should have their day in court. If you were wronged, you should get a judge to hear, and maybe even a jury to hear, what your argument is. And the evidence should be produced, and like we try to give people an opportunity to get justice. So many judges, as a default, don't like, not just in a case like this one, but generally, don't really like throwing out lawsuits super early because you feel like you're clipping the wings of a plaintiff who may have been wrong. Even, like, you don't know, because the judge doesn't know who's telling the truth here yet. There are a lot of records, and I believe under the First Amendment that this was protected speech, because I think the First Amendment is strong, and there's a lot of reasons why I think what I do, and I've talked about that in previous videos. But at the end of the day, frequently judges feel it's not fair to throw out cases right at step one, and you want to give them a chance to develop a little bit to see whether there's something there in terms of injustice and like righting a wrong. So it's not like totally crazy that the judge would keep the suit going at this point. What is crazy, though, to me at least, is just like how little discussion there actually was here, how lackluster the arguments were that the judge made. It seemed to me really lazy. Maybe that's reading in bad intentions. I don't know, but as I said, I've worked for judges before, and this wouldn't cut it. This just simply, like, after this many briefings back and forth, a few paragraphs discussing the core argument wouldn't cut it. And so I'm surprised it did here. Anyway, I think those are all the main points. Please let me know if you have any other questions. I'll try to maybe make a separate video about that. I'm going to be out of the country for a little while this fall, so if there are developments, then once again, there will be a gap in me publishing. But I'm hoping that I'll be able to make these updates more consistently as the records are actually produced and as court filings become available. Thanks everyone for watching. Please subscribe if you like it. This is a lot of dense content to get through, and yeah, have a great week.